Hello, everyone. A very good evening. And after the lockdown, we've had multiple lectures. Thank to Adivakta Parshad. And today we have amongst us Mr. Som Mandal, Managing Partner of FoxMandal, to discuss amongst us the topic foreign lawyers and reciprocity. Uh, and I'd like to give you a brief introduction of FoxMandal and Mr. Som Mandal. Though it would be a cliche, he does not require much of an introduction. He's a person who's got a very phenomenal domestic and foreign practice, one of the leading names in the M&A, mergers and acquisition circles, a leading philanthropist in the country. He was recently just talking to us about the work that he does around the Durga Puja and health-related service that he provides in the state of West Bengal. And his firm is one of the oldest solicitor firms in the country, with extensive practice in all metropolitan cities and extensive practice in Europe and to a limited extent across Southeast Asia and North America as well. Sir, thank you for being amongst us today. And today he's going to be talking on foreign lawyers and reciprocity. We have seen two important cases out of the Madras High Court and the Mumbai High Court and the Supreme Court to talk about foreign lawyers. 2 years have elapsed since the Supreme Court having passed such an order on fly-in, fly-out lawyers. And we have had a lot of Indian lawyers now take in foreign lawyer roles in Singapore, Hong Kong, and even the likes of Sri Harish Salve and Gopal Subramaniam practicing out of the UK. So in light of that, we would like to learn more on the subject and where we stand today after 2 years of the Supreme Court passing an order. Please, sir.
Thank you, Ram. First of all, respected elders, learned brothers and sisters, ladies and gentlemen, namaste from London. I hope all of you are keeping well and keeping safe at home. I'm saying this because I'm away in London and got stuck up here due to the COVID situation and unable to return back to India in time. And I'm very happy that Adivakta Parshad has given me this chance today to speak on the Dattopan Tenuri lecture series, and I'm really grateful for giving me this opportunity to speak today. At the outset, I would like to say that my speech or my talk today is a very personal view of mine, and I chose this topic because this is a burning topic for many years, and in recent times, it requires a lot of discussions, and I feel that this should be discussed and debated amongst lawyers in India in general. Currently, all of you, as you know, that foreign lawyers are not allowed to practice in India. There are Supreme Court judges, as Ram just said, that Supreme Court judge, as well as Supreme Court judgments, as well as there was Mumbai High Court judgment and a Chennai High Court judgment, which prohibits foreign lawyers from practicing in India. My discussion today would be mainly concerned or mainly circle around what the legal situation around the world is. And I would then briefly discuss about the judgments and then a bit of my suggestion as to what is going to happen or what we should do. Now, we all are lawyers, and as you may know, that when we talk about lawyers, people generally think that a lawyer is a person who wears a black coat and goes to the court. But they have no idea, or many of the people or even lawyers don't have an idea that lawyers do much more. They actually draft documents, complex documents. They do negotiation. The central government, the state governments, very big corporates, social organization uses lawyers for a various paraphernalia of activities, which includes, even drafting of IPO documents, defense deal documents, power purchase, telecoms, and various other documents, which are also part of lawyers' activities. And I think this part of lawyers' activities has never been much given importance by the Bar Council of India for many years. Now, when I am talking about these two sets of lawyers, as I said before, that there are lawyers who are litigation lawyers and there are lawyers who are non-litigation lawyers. And in order to show that, I would say that how the lawyers are enrolled in various, first I'll talk about India and then about how lawyers are enrolled in various other countries. The foreign lawyers are generally looking at India to take the space of non-litigation lawyers. And I think that is where a lot of issues have come up. All the cases that has gone to the courts, various courts, are in relation to the non-litigation practice by the foreign lawyers. Now in India, as you all know, the Advocates Act came into place around 1961, and all lawyers are one class of lawyers are all called advocates. Obviously, there is also a definition of a senior advocate under the Advocates Act, but generally all lawyers who practices law in India are called advocates. There is no generally distinction between a litigation lawyer and what is a non-litigation lawyer in India at the moment. If you look at most of the Commonwealth jurisdiction, or if you look at even even the other jurisdictions such as US, Japan, who are not within the Commonwealth, they all have a system where they enroll law firms or non-litigation lawyers, as well as lawyers who are litigation lawyers. I will start by saying about England. Just a minute. In England, a lot of you know that there are generally two sets of practice. One set of lawyers who goes to the court are called barristers, and then the QC levels are called, the senior advocate levels are called QCs in England, while the other lawyers who are practicing in the law firms or who are doing non-litigation practice are called solicitors. And there is entirely two different sets of practice. The barristers get enrolled before the Bar Council of England and Wales, while the solicitors gets enrolled before the Law Society of England and Wales and Solicitors Regulatory Authority. These are the two sort of authorities for solicitors. The if you look at the US model, the US model is somewhat very much like the Indian model, where the state bar is the enrolling authority, and they have the American bar at the top. So unlike in India, in US, if you are enrolled in one state, you generally cannot practice in another state, but you have to either get an exemption or you have to sit for exams in the other state to practice in that other state. However, in US, what happens about a law firm? Now, if an individual lawyer or a small group of lawyer wants to open up a firm, they would have to register what they call professional service liability, limited liability company, or if it is a smaller firm, they sometimes do professional service corporation, and the bigger firms do LLP, which is the limited liability corporation, limited liability partnership. Now, having said this, there is also a system where before the law firm is established, they have to go to the state, respective state, and they have to also get permission from the state, not only about to set up the firm, but also to clear the name. So unless you get the clearance of the name, so that there is no firm by the same name anywhere else in US. So they get a name clearance, and then after the registration, they start practice. There are a lot of other formalities that in the US, there is a compulsory insurance, whether you are a litigation lawyer or non-litigation lawyer, you have to take insurance for negligence, which is a very important aspect of practice in United States. If you look at Australia, if you look at Canada, if you look at Singapore, Japan, almost all states have similar provisions, and they all require lawyers and law firms to separately register. And then they have the system of insurance, which are almost compulsory in all the jurisdiction I mentioned and many other jurisdictions. In India, as you all know, it's establishing a law firm is very easy. What does an Indian law firm have to do to establish a law firm? They just have to set up a partnership firm and start practicing law. Now, There is no professional requirement of the law firm to get enrolled at any place or any register in India. So we do not actually have at this moment a statistics or any rules and regulation guiding the law firms in India. The Bar Council, as we all know, have a system where a lawyer gets enrolled in any state, and they are allowed in India to practice all over the country. And I think that is where the difference lies, that between India and other countries, that the Indian lawyers just require to enroll themselves with one state, and they can practice anywhere else within India. As I said before, that within the Bar Council of India, there is no system of any enrollment of law firms. The Bar Council do not necessarily at this moment have any rules governing law firms. And as a result, I think many of the law firms go scot-free so far as their negligence or their liabilities are concerned. If you look at other countries, as I said before, insurance by the lawyers is a prior condition at the time of getting enrolled, and they have to start practice after taking insurance, which obviously is missing in India. So the lawyers are much more dedicated, and I think the lawyers are much more concerned, or I would say much more responsible in giving their advice. At least they are challenged by the clients or other lawyers in India. In India, I think one of the reasons why Bar Council have not really looked at the law firms is probably the fact that 90% of lawyers in India are litigation lawyers. Perhaps that's one of the reasons why the Bar Council has never looked really at the law firms or the practice of the law firms. But that's where the actual problem lies. And the rules and regulations are very important for the law firms in order to for the clients in India to get a proper and responsible advice here in India. If you look at going back to this question of accountability, if you look at India, even individual lawyers, what at the present what we have, I mean, if there is a issue or issue of negligence by an individual lawyer, what one can do is one can file a complaint before the Bar Council of India or the State Bar, and one can appeal to the, if they're not happy, one can appeal to the Bar Council of India, and then one can go to the Supreme Court. I think that's where the problem lies. We do not have an independent body to look at our cases against lawyers. I think it's important maybe for us to have lawyers separate regulatory authority who would look into these aspects, which would make an independent judgment. I believe that the best practices with the foreign firms are something that our lawyers and law firms in India should learn and follow. For example, strict conflict checks, maintaining of proper records of time spent on each of the matters for the client, use of document management system. Each of the lawyers and law firms, as I said earlier, have taken out professional indemnity insurances, and therefore they are very cautious in their approach when they give opinion to their clients. The next is that generally lawyers internationally, you've never heard of lawyers going on a strike because they are, all responsible, and they have a duty towards the client, and the insurance that they have taken prohibits or stops them from doing anything which would be a negligent towards their client. Client confidentiality is of utmost, which foreign lawyers really respect. And I think that's something that our lawyers and law firms need to respect much more. Secondly, the technology used by the international law firms is important aspect of the legal practice, and our country needs to gear up from from that front. These are practical trainings and cannot be taught in the universities. International law firm puts a lot of resources in technology, which ultimately the Indian law firms have to do and teach their lawyers. And I think some of the Indian law firms are already taking steps in that direction. Thirdly, our young lawyers graduating from law universities are excellent, but they need more exposure and training. If foreign law firms are allowed, they would take a lot of our students as intern or junior associate, which they already do to some extent, but they do it in foreign countries. However, if the Indian foreign law firms are in India, the interns and junior advocates would be admitted to in India, in their firm, and there would be less brain drain of good lawyers from India. And I think, as you may all know, that most of our universities today, all the top ones, they have recruitment by foreign law firms. Many of the foreign law firms takes our brilliant students away from India, and they work in international law firms outside India, and generally most of them do not come back or want to come back to India because they are comfortable in working abroad. I think that's where, if the foreign law firms are available in India, those situations will not arise, and we would have the opportunity and the benefit of good lawyers retained in India. I think that's very important, and we should note about this as well. Pausing here for a moment, I would like to say that competition within law firm is fierce anywhere in the world. I mean, if foreign law firm comes here, Indian law firms have to compete quite a lot. Everybody protects their territory, and I think there is nothing wrong per se in that. If I'll give you one small example. This is something that I faced, and I feel how a foreign law firm was protecting their territory and their client is an example from here. Some years back, there was a disinvestment in India, and in that disinvestment, our firm was retained by an international law firm to advise them on that disinvestment for their international clients. Our firm worked with that international law firm, and most of the work, since it was related to India, was done by our firm, and the international law firm actually, based on our work, added more value to it and charged the client maybe 5 times more than us. That's fine. We charged our fee and they charged their fees. What I'm going to now say is very interesting. Now, the foreign client who got the service from us through the foreign law firm, thereafter was so happy with the work of our firm that next time that they had a project in India, they came directly to us. Now, as a matter of principle, and as I said, we need to be transparent, I called back the partner in the firm who referred that matter to us and worked with us in that earlier matter, saying that, look, the client who you referred last time has come back to us directly, and what we should do. He said, oh, very good. They were very happy with your work. Why don't you work with that client? That was it. Very good. Happy. Everybody's happy. The client had another piece of work after a few months. I again called up the partner of the large law firm, international law firm, and he said, oh, Som, that's good. They are very, very confident about your services, and I hear good things about your firm. You're doing very well, but don't forget us. I said, yes, fine, that's okay. Then there was another opportunity when there was another disinvestment in India, and this big law firm felt that they should come in. So fortunately, the client then directly, instead of coming via that international law firm, come directly to us and started working with us. Now, when again I called up the partner, his answer was, Som, I think this time you need to get us in as well. Now, having said that, partner of the law firm did actually introduce us to this client, I was at some point of time almost sort of forced to tell the client that, look, it would be good, since it's a bigger deal, that you should have that international law firm also involved in this transaction. Frankly speaking, that was not required, but I did ask the client that they should be bought in. And now see what? After I or the firm got involved with the international law firm, we started getting questions from the international law firms regarding the work that we have already done in that project. And they started questioning us for every aspect. And at a certain time, they said, Shom, the clients are not very happy with your work, and we have to change firm. Look at the way the foreign client behaved. They were doing nothing but protecting their territory. They were protecting their client. They were feeling threatened. So Indian law firms can perform. This is a clear example where we should not be concerned, or we should not be at all fearful of any competition from any foreign law firm. Now, moving on, my views about foreign law firms in entry has been very aggressive and blunt, and for that matter, there has been a lot of issues which other law firms in India have against me. But a view which I have always held, that foreign law firms should be come to India, is not looking at our own firm's interests, but looking at the interest of young lawyers and India in general. And that's the view we have taken. A lot of people ask us, why are you supportive of foreign law firms? And I think one of the reasons why I'm supportive of, or our firm is supportive of foreign law firm, is that there are a lot of things that we need to learn. And I think every day we learn. And certain things we can't learn remotely, certain things we cannot train. If foreign law firms comes to India, I believe that there would be a lot of people who get trained in those firms, and later on, when they move out, they will actually join firms like ours and other Indian law firms. And when they join, they bring with them the training that they got from the foreign firm. And I think that's where the whole ethos lies. And I think that's what we are looking at, to bring in the expertise that they learn from foreign firms. It is true that many of the Indian law firms do not have the technology the way the foreign law firms, and it is important to learn. And I think we as a law firm, and I as a person, I'm not ashamed of learning. And I think we are learning continuously, and we should keep on learning. Now I'll come to what I feel the foreign law firms want from India. And thereafter I will discuss other things, but I will first highlight what I believe and understand, talking to various law firms around the world, what they want in India. Their first intention is to be able to advise their clients when they are in a new jurisdiction, and therefore they require a legal presence in that jurisdiction. So in this case, we are talking of India. Then the next intention is that where they're able to advise their clients on foreign law issues vis-a-vis their investments in India. So when they have an office, first they want to have an office. Second, when they have an office, they want to advise their clients relating to their country's law vis-a-vis the Indian law, and guide them how to do the investment. Third, the intention of the foreign firm is to advise Indian companies who are looking to invest outside India, or who are to give them advice in India. So the Indian companies do not have to travel abroad, or they do not have to sort of make contacts with foreign lawyers outside India. They can just visit a law firm, international law firm within India, and take advice. It saves money, time, and cost. And I think that's what foreign lawyers are also looking to do. Then I think the next intention of the foreign law firm would be to hire Indian lawyers, and certainly advise on certain non-litigation related issues, which would be much down the line. And I can assure you, most of the firm, and I haven't come across many firms who really intend to do any practice anywhere else outside their main jurisdiction. And most of the countries, in any case, do not allow lawyers of foreign countries to come and practice in their jurisdiction. So I think there is absolutely no issue for the foreign lawyers. They are not allowed to do litigation practice. So I think my litigation brothers and sisters should not have any concern at all from the foreign lawyers, which over the period of time they have been hammered with the thought that these foreign lawyers who speaks very good English will come to India and go to the court. No, they will never go to these courts. They will never go to the district courts. They will never go to any courts. And in fact, they would actually support the litigation lawyers. I think that's what Indian lawyers, litigation lawyers who comprises even now 90% of our lawyers community should understand that foreign lawyers will come here and support Indian lawyers rather than taking away their work. And I think that's what one needs to realize. And I think we don't realize that, or we are given a different view about that. And I think that's where I'm very blunt in telling people that litigation lawyers should not be scared at all. In fact, they would benefit from foreign lawyers coming into India. Having said all this, foreign law firms I have seen and spoken, as I said earlier, they are very open, as in most of the countries, or a phased manner of entry. I had said just before the ways that they would like to come to India. I think primarily if they're allowed to set up an office in India and practice their law, which is a foreign law in India, I think that would itself be a big step for them. And it would also help Indian lawyers understand what the foreign lawyers want. And I think the foreign lawyers are ready for a phased manner in any countries around the world. If you look at, it has never been a straight entry. It has always been a phased entry. Most of the foreign countries, even now, only allows foreign lawyers to go and practice foreign law. If they want to practice the law of that country, there are a lot of restrictions, a lot of exams, a lot of other things that needs to be done before they are admitted to practice in that country. So foreign lawyers coming to India would never look to practice Indian law for the moment, that's for sure. I think, having said this, one should realize that the Bar Council of India would actually have the entire control, because if the foreign lawyers are to come to India, it's the Bar Council of India who has to first make rules for them. And it is for the Bar Council to put whatever strict rules that they want to put for the foreign lawyers. But before that, I think the Bar Council, I strongly believe that the Bar Council should make out laws for the non-litigation lawyers and the law firms in India, for a system of registration of law firms, setting the rules for law firms, which would then pave ways for setting up rules for international law firms and foreign lawyers to come under the reciprocal arrangements that we have already within the Advocates Act, which I'm going to talk in a short while in India. Now, I would like to talk a bit about what actually led to the Mumbai case. So before I come to the Mumbai case, I will generally talk what actually started and how it all happened. How did the foreign law firms actually get into India? You may all know that prior to 1961, there are foreign law firms who have been in India. When I say foreign law firms, it may not be a foreign law firm, but a foreigner coming in India and setting up a firm. Say, for example, our firm. Our firm was established in 1896. A gentleman, Mr. Fox, from England, who was qualified in England, came to India, was practicing in India. He was allowed to practice, obviously, at that point of time. He then, with my great-grandfather, set up a practice, joint practice, and named it FoxMandal in 1896. Now, which means foreign lawyers were allowed at that point of time to come to India and practice. If you look at many of the Indian law firms who have anglicized names like Mulla, Craig, Blunt and Cairo, and various other law firms in India have, I think, the law firm in Calcutta or Dignam, Sanderson Morgan, names such as that. These are all English lawyers who have set up offices in India many years ago, and there was no issues at that point of time. But I think what started the present set of issues to come up arose generally after the liberalization that has happened in India since 1991. And I think that was the first batch of issues that came up again about foreign lawyers practicing in India. I'm going to say a few examples also during while addressing this issue. Um, when the economic liberalization in 1991 happened, there were a lot of foreign law firms like Ashurst, Morris Crisp at that point of time, now called Ashurst, White and Case, Chadbourne and Park, and few others set up a liaison office in India by taking permission from the RBI to set up a liaison office in India. That was the model that was used by the law firms way back in 1991. They were allowed, and nobody actually stopped them from coming and setting up a liaison office. They were not practicing Indian law, they were practicing foreign law advice, and they set up a practice through this, or consultancy practice by setting up a liaison office. The reason why these international law firms were looking at that time primarily was because of the economic liberalization, as you all know. There were a lot of international companies who were coming to invest in India. And one of the things that any large international companies, when they go to another country, generally they want for their own peace of mind and satisfaction, handhold by their lawyers. Even in their own country, they would use a lawyer, unlike in India, where Indian companies don't use lawyers to that extent. Foreign companies have been used to using their lawyers almost for every single thing. So when they obviously started coming and economic liberalization happened in India, they were looking to have their own lawyers side by side with them. And that was the reason why some of these law firms established themselves, and some obviously without establishing came along with them and operated out of hotel rooms and worked with them, and nobody said anything at that point of time. Mainly these areas where Indian law firms did not have expertise, like telecom, power. Like, I mean, Indian law firms never did power projects, or I mean, large power projects, drafted power purchase agreements, or complicated financial power purchase structures, or loan documentations. These were things that were not really common or never happened before. And as a result, I think the foreign lawyers wanted to fill that gap and come with the investments of these companies. Like Enron as well came into that time. AES also came in at that. These are power companies who came in at that time. They all had their foreign consultants or the foreign lawyers to help them in India. These foreign lawyers, obviously at that point of time, also worked with Indian lawyers and supported the international companies. Now, there's one example I would like to give, that around that time when all these liberalization happened, the state of Orissa were looking to disband their state power grids, and they actually did an international RFP and appointed an international law firm called Cameron McKenna. Now they are called Cameron McKenna. It used to be Cameron McKenna. Now they are, I think, called just Cameron. And they came and they had a partner based in India, a couple of partners based in India out of Bhubaneswar, and they advised the power ministry of the government of Orissa, and later on they also advised power ministry of the government of Madhya Pradesh and few other states to how to restructure their power grids and how to make the power corporation within the state much more viable. And also they looked at the distribution system as well. So they actually um, appointed these international consultants because they had the expertise. Let's be candid about it. Indian law firms did not have the expertise, and the foreign law firms which did much privatization work of electricity, they knew all this and what are the World Bank issues, because many of these state power corporations were trying to get funding from international institutions like World Bank or other international institutions. And as a result, they also had to make their system as per international standards. And I think that's where they had to rely upon the international law firms. Now, when this was happening, the Indian law firms who were primarily, till at that time, 1991, were primarily working on litigation. And mainly when they were talking about corporate matters, it was mainly company law matters or few IPOs where they used to give opinions and due diligence. There was not much corporate matter that was happening. There was no obviously work much in the power sector or the telecom sector. And I think the larger Indian firms saw that this is an opportunity after seeing these international law firms, that this is an opportunity that they can make money, and they can make money much more than their litigation practice. And I think that's where the Indian law firm started looking to expand their practice from litigation to non-litigation as well. Around that time, the issue of Mumbai case came up. It is perceived by many, and there is no substantial fact or nobody can prove. But some of these law firms actually caused the lawyers collective to file the petition before the Bombay High Court. There was no generally any reason for lawyers collective, which is primarily a litigation firm, to have jumped to defend the non-litigation territory in India when foreign lawyers never transgressed the path of litigation lawyers in India at all at that point of time. So I think it was through some motivation that lawyers collective started this litigation in the Mumbai High Court in 1996 and filed a petition, writ petition challenging mainly that Indian foreign lawyers under the Advocates Act are practicing Indian law, which they cannot. And they were also operating through a liaison office, which is not controlled by the Bar Council of India. Therefore, it is wrong for the government of India to allow such law firms to operate through liaison office. And I think now I'm going to say something about the Mumbai judgment. I'm of the view that this judgment is based absolutely on wrong and erroneous facts, and the court failed to distinguish practice of Indian law and the practice of foreign law are two separate issues. Some of the vital points were either not argued or not taken up by the counsels arguing the matter. There's a basic error, I think, on the part of the court to hold practice law to include practice of foreign law as well. I think when the framers of the Indian Constitution framed the Advocates Act, they did not consider the practice law would mean practice of foreign law as well. It would only mean practice of Indian law. What the Mumbai court held was that the practice law in section 24(1)(a) of the Advocates Act would include practice of litigation and non-litigation. And I do agree that it was the correct view. And I think it was very important view that both litigation and non-litigation lawyers exist in India by that definition. However, what I don't agree there is that how the practice of law would also include foreign law and not just Indian law. It is correct to say that practice law would include Indian law, but not the foreign law. I'm making that distinction, and I think the framers of the Act of the Advocates Act were only concerned, as I said, with the Indian law and did not specifically or stopped within the Advocates Act anything which says that foreign lawyers cannot practice in our country. The Advocates Act dealt mainly with the Indian law and how a person in India is allowed to practice as a lawyer. The framers, according to me, did take into consideration that foreign lawyers actually can come and practice in India. In fact, if I go to look at the Advocates Act, there are two sections which clearly talks about foreign lawyers practicing in India. And I think the framers at the time of framing the Advocates Act did take into consideration if foreign lawyers actually ever come to practice in India, how and how we should deal with it. I would take time to read these two sections. It's very important, and I believe it's for all of you to look at it from the way I'm reading it. Section 24, 1A says persons who may be admitted as advocates on a state roll, subject to the provisions of this Act and rules made thereunder, a person shall be qualified to be admitted as an advocate on a state roll if he fulfills the following condition, namely, A, he is a citizen of India, provided that subject to any other provisions contained in the Act, a national of any other country, a national of any other country may be admitted as an advocate on the state roll. What does the Act says? A national of any other country may be admitted as an advocate on a state roll if citizens of India duly qualified are permitted to practice law in that country. It is absolutely clear, unambiguous, and I do not see any reason why nobody ever, while arguing, put stress on this point. The second is more on a negative way, but it says that Section 47, it talks directly about reciprocity. It says, where any country specified by the central government in this behalf by notification in the official gazette prevents citizens of India from practicing the foreign law, profession of law, or subject to them to unfair discrimination in that country, no subject of that country shall be entitled to practice profession of law in India. So this section also talks about that if a lawyer is not allowed to practice in another country, so it's in a negative way. So the reciprocity is in a, if you are not allowed to practice in another country, you cannot be allowed to practice here. What does it mean? It means that if you're allowed to practice in the other country, you will be allowed to practice here. And I think these are the two section which was not really argued or looked at in much detail. The section 47.2 says, subject to the provision of section 1, the Bar Council of India may prescribe the conditions. That's where the main point is. So it is not the Parliament, it is not the Government of India, it is the Bar Council. The Bar Council of India may prescribe conditions, if any, subject to which foreign qualification in law obtained by a person other than the citizen of India shall be recognized for the purpose of admission as an advocate under this Act. It is absolutely unambiguously clear. As we can see from the above two provisions, the framers of the Act very rightly thought that foreign lawyers practice in India can come in, and made certain provisions allowing the Bar Council of India, when the time comes, to frame rules in this area as well. Here, I would like to say that dual qualified lawyers of Indian origin have taken advantage of these provisions and have come to India and have set up shops. For example, there are lawyers who have trained abroad, but because of their perhaps nationality or because of their Indian origin, they have come back to India, got themselves admitted to Indian bar, and set up office for that law firm. There are still few lawyers from different firms internationally who have set up shops in India and practices as an arm of that international law firm. So there is already foreign law firm exists in a different way. I would even go to the length of saying that the provisions of the Act, as I read above, with the judgments of the courts, clearly allows foreign lawyers to practice in India, but it is only up to the Bar Council of India to frame rules, not only for foreign lawyers, but also for Indian law firms or the foreign law firms as well. It has never, as I said, been argued before. These points have never been argued before the court. And I think it's high time that the Bar Council seriously looks and considers these issues in a much more open mind and more closely. I feel the issues framed in the Mumbai case, according to me, are not correct, and the council representing the foreign lawyers ought to have put forth many more relevant issues before the court for consideration. As I said before, the points that I raised were not seriously or argued and not placed the way I did place right at this moment. According to me, the Act already empowers the Bar Council of India to make rules for practice of lawyers in India, and as such, also empowers the Bar Council to make rules for foreign lawyers' practice, and there is no need for any amendment anywhere whatsoever for Bar Council to go ahead and frame rules. The Advocate Act is very clear and unambiguous, as I stated earlier, for how a foreign lawyer can practice in India. And Section 47 the talks about reciprocity, and I think that's one of the ways that foreign law firms can come in India. I strongly believe that the foreign law firms who ought to have challenged the Mumbai court judgment in the Supreme Court, unfortunately, they got tangled with another case, which I'll come very shortly, in Chennai, and was not able to challenge it in the Supreme Court. There's a misconception that Indian lawyers have no reciprocal arrangement. I've already talked about it. Many countries, as you know, allows Indian law firms to set up offices. Many of our large, medium-sized Indian law firms have offices in cities like London, US, in various cities in US, Dubai, Singapore, Japan, and our firm itself did have an office in London between 2006 to 2012. And I think there was not even any issue to set up the non-litigation practice. So we clearly just set up an office here and started practice non-litigation work in India, advising only on Indian law. Now, if I go back to Section 47, it clearly says, or 24, there is a reciprocal arrangement. So if England allows Indian law firms to establish non-litigation practice in UK, similarly, the Bar Council ought to consider allowing UK lawyers to practice under such circumstance in India. I think there are lots of guidelines by different states how foreign lawyers in their countries will come. And I think obviously while considering these rules, the Bar Council ought to study the rules and other issues that are guiding factor for foreign lawyers practice in those countries, and they should obviously take into consideration within the Indian context and set up rules for foreign lawyers to come and practice in India. I will touch down very briefly on the issue of foreign lawyers practicing in Singapore, which is very interesting. Singapore had recently allowed, I would say recently, when I say recently, some years ago, allowed few law firm who were given license to practice Singapore law. It was the discretion of the Attorney General of Singapore to allow few law firms. So there was a short window where first come, first serve. Few law firms, international law firms, allowed to have full practice in Singapore, and that license just closed. I think there are about 8 or 10 licenses that was handed out to various international law firms at that point of time. Generally, a foreign law firm can go and set up office in Singapore and follow the rules through the Law Society of Singapore. they can practice in Singapore, Indian law, or foreign law, wherever the law firm is from in Singapore. The Singapore government or the Singapore Law Society has also allowed setting up of joint ventures. So international law firms can set up joint ventures with a local Singapore firm and practice non-litigation work. So when I say so what happens basically when a international law firm have a joint venture with a Singapore arm, they have two sets of law firm. One is the joint venture where foreign lawyers and Singapore lawyers are practicing international law or basically non-litigation law, including non-litigation Singapore laws. And on the other hand, the Singapore joint venture partner, which was the originally a Singapore firm, they retain the litigation practice. So they file all the litigation matters for that joint venture. So see, within the law firm, there are two entities. One is doing the filing in the court and arguing the litigation. The other arm, which is the JV, is doing the non-litigation work. So, I mean, there are different ways, and one can be innovative, do various other things. And I think that is where the point is that the Bar Council should look at and study all of these. And I think it's very important that we seriously look at these options in various countries. The foreign lawyers, after the Mumbai order, were very restricted and started working out of the hotel rooms. Many of the foreign lawyers were spending more than half of their time in India, as a result of which many of them were spending more than 90 days and were hauled up by the tax authorities in India. And many of the lawyers received notices from tax authorities and had to go to the tax tribunal to file cases, which obviously made the life of foreign lawyers complicated in India, and they started taking a backseat. Around this time, some of the law firm started setting up best friends in India. As you know, there are some of the UK firm and US firm formally set up best friends with some of the large Indian law firms. And although that did not last for long, but the other bigger law firms who were trying to have a setup, or they were not confident of competing with the foreign law firms, they then were looking at how to continue stop entry of foreign law firms to come to India. And I think one of these factor later on led some of these Indian law firms to push for another litigations to start in Chennai. Some of the issues which were never discussed or never raised in the Mumbai court were then put up before the before the Chennai High Court. And I think there were many issues that came up before the Chennai court, as you may have seen. I think the Chennai judgment is much more open, and I think the international law firms fought and argued the matter in a much more coercive or much more I would say in a much better efforts. And but some of the important points were still missing, and they were not argued at all. In fact, the writ petitioner in Chennai, who is a lawyer himself, referred to section 24 in paragraph 21 of the judgment, but it was never really taken up seriously by the foreign lawyers. Further, if one looks at the reasoning court from paragraph 39 to 63 of the judgment, although it takes into consideration many of the arguments put forth by the Council of the Foreign Law Firms, but totally ignored the references of section 24 and 47. These are the only two sections, as I said before, deals with foreign lawyers and the reciprocity in India, and nobody really take these two sections for arguments further. The Bar Council strangely preferred an appeal in the Supreme Court from the Chennai High Court order. And I would like to point out before I finish on this issue that one of the Chennai counsel, while arguing before the Madras High Court, said law can never be static and be confined in the hands of a restricted group or individuals, especially in the present context of developing global economy. And I think it was rightly put that we cannot just be confined to where we are. We must move on. In the same case, Mr. Krishnamurthy, who was a learned senior counsel appearing for a couple of the law firms in UK, submitted that the Bar Council of India regulates advocates enrolled in India. Law firms as such are not required to register themselves before any statutory authority or require permission to engage in non-litigation practice. That's what I have been saying in all my talk today. In other words, Indian law firms are open, operating in a free environment without any registration or regulation, and the oversight of the Bar Council with regard to such non-litigation activities of law firm is virtually non-existent. By exploiting this loophole, many accounting and management firms are employing law graduates and rendering legal services which are contrary to the Advocates Act. In these circumstances, it's high time a proper framework of regulating law firm is put in place. Exactly what I've been saying today, that it is important and it's the right time that the Bar Council seriously consider this. In the same case, I would like to also quote a submission made by the Government of India in their counter affidavit, which is noteworthy to mention, and I quote, "It has been stated that law firms as such are not required to register themselves or require permission to engage in non-litigation practice, and that Indian law firms elsewhere are operating in a free environment without any curbs or regulation. It is further submitted that the oversight of the Bar Council on non-litigation activities of such law firms are virtually nil today. Now, and exploiting these loopholes, many accounting and management firms are employing law graduates who are rendering legal services, which is contrary to the Advocates Act. Therefore, the concern of the Government of India, as expressed in the counter affidavit, to be addressed by the Bar Council of India. Further, it is seen that the government, in consultation with the Bar Council of India, proposes to commission a study as to the nature and activity of LPO, and appropriate decision would be taken in consultation with the Bar Council of India. So the government also did highlight and point and raise the issue for discussion. Now, before coming to my end of my speech, and I've already spoken for quite some time, and I understand there is a question answer sessions after this. I would be very brief. I would now discuss very briefly about the Supreme Court judgment. By this time, as you know, the foreign lawyers were totally exhausted fighting so many cases in India, and then to come to Supreme Court. In the meantime, the international economic condition was such that there were hardly much non-litigation related work coming out of India. So the international law firms' interests coming to India also waned considerably, and the Law Society of England and Wales and the American Bar Association were not pushing or taking steps as before, and they were much more relaxed in their approach. In the Supreme Court judgment, I will point out only two highlights, and I will read out two areas of the judgment. The present court noted that practicing of law includes not only appearances in court, but also giving of opinion, drafting of instruments, participation in conferences involving legal discussion. These are part of non-litigation practice, which are part of practice of law. This, stopping here for a moment, I would say this, my humble submission, this is an admission by the court that there are non-litigation lawyers who also come within the Advocates Act, and distinguishes that there are two categories of lawyers. One is litigation lawyers and the other is non-litigation lawyers. The Advocate Act makes it clear that the advocates enrolled with the Bar Council alone are entitled to practice, except as otherwise provided in any other law. Stopping here again, I would say that Section 24 and 47 would have come into play, although the Supreme Court did not really touch upon it. All other could appear only with the permission of court, authority, or person before whom the proceedings are pending. Again, here the court was talking about litigation lawyers and not talking about non-litigation lawyers. Although the court says the Advocates Act covers both the lawyers, but the court actually was only talking about litigation lawyers and not talking about non-litigation lawyers. The second point, which the court said, there is absolutely no bar for foreign lawyers for conducting arbitrations in India. And if the matter is governed by a particular rule of an institution, there is no bar to conduct such proceedings in prescribed manner. If the matter is governed by an international commercial arbitration, conduct of proceedings may fall within the provisions of the Arbitration Act. Even in such case, code of conduct, if any applicable to legal profession in India, had to be followed. Now, the court obviously dealt with the arbitration lawyers or lawyers so it is partly practice of litigation and not non-litigation practice. Now, having said all this thing, I strongly believe that the law firms who are really interested, so this is a message for the international law firms, that if they are really serious in looking to establish something in India, they should take advice from proper lawyers who are convinced that foreign law firms ought to be allowed in practice in India. There is a big conflict of interest for the foreign law firms seeking advice from Indian law firms on their entry strategy into India, who are openly against the entry of foreign law firms, which most of the foreign law firms at this moment have been doing, is using Indian lawyers who are opposed to foreign law firms entry. They were using the same law firms, and it's very important to note and a message to the foreign law firm that they need to look at it from a very different angle. Now, in conclusion, I would say three things. Foreign law firms ought to visit India, several Indian law universities, and raise issues and seek their support. They ought to educate them about the legal profession worldwide and provide them a wider version. The second, if you ask the law students community, I'm sure, and I've asked that in few universities, most of the lawyers, most of the law students have a consensus that the foreign law firm should be allowed in India, and perhaps it's high time the Bar Council ought to look at the majority view of the legal community, including the future generation of lawyers, which is the law students, into consideration while framing the rules. The last suggestion, the Ministry of Law and Justice, in consultation with the Attorney General's Office and the Bar Council of India, should form a committee with some of the Indian law firms to frame the rules for registration of not only Indian law firms, but also registration of foreign law firms in India. And that brings to the conclusion, and I'm now ready for any question answer. Ram, please.
Thanks a lot, sir, given your busy schedule, not just amongst mergers and acquisitions, but also in policy making and advising a lot of state and private bodies, to have taken the time for us. We understand sir has placed a very important opinion, a very detailed platform through which India has seen the evolution of foreign lawyers' position and the court cases. And understandably, this is a subject of great debate across the country. There's a extreme opinion on the other spectrum as well. And Adhivakta Parishad particularly is of the view that all the lawyers and all the people, stakeholders, should understand the pros and cons, have a detailed discussion, and understand the issue at hand, and then take carefully considered decisions. And sir, further to that, we would like to go to our first question. Our first question comes from one of our readers, Falguni Gantiwala. Thank you so much for providing such informative information. Can we Indian lawyers go abroad and practice the same? Sir, I think this comes from a background. Do we need to have bilateral agreements before lawyers go out and practice? Or do they need to be just enrolled in the respective countries? Or is it open to practicing?
As I said earlier, there is absolutely not any stifling law or rules when an Indian lawyer goes to a foreign countries. Obviously, all the most of the countries allows, most of the developing countries, I would say, allows Indian lawyers to set up a practice in their country, but they should be confined to practicing Indian law. Each country has different sets of rules. Some countries has slightly more, some countries has less. In England, for example, when FoxMandal opened an office, I went to the Law Society and asked them, what do I need to do? Do I need to fill something? They said, no, you just open up a bank account and start practice. And that was as simple as that. So what happened was we just set up a bank account in the name of FoxMandal and started practicing as FoxMandal in London. Some countries do require certain registration with the concerned bar, but the formalities are not very stifling.
Pleasure, sir. And next we have a question from Mr. Bagel. There's a huge difference and gap between how urban environments, and particularly practice in the higher and the appeal courts in India, and in other Mofussil and district court practice. So how do you distinguish when these foreign firms come in? How would it impact these large firm practices in the urban areas and other townships?
I think it's a very pertinent question, and it's important that he has raised this question. If you look at from a foreign lawyer's perspective, when foreign lawyers are looking to come to India, obviously, as I said before, they do not want to practice laws, litigation law. So what happens is when foreign lawyer comes to India and their client has a small matter in, say, a district or Mufassil court, as he has raised, what would the foreign lawyers do? They will directly go and find a good Mufassil lawyer and instruct them directly and not involve any other Indian law firm. So that is where I think the benefit goes directly to the litigation lawyer in the Mufassil courts, that the foreign law firm who is established in India, their clients requires an advice from or a legal court case in the Mufassil court. They will go directly and pay in much higher amount than they would have otherwise got from any other clients. And I think that's the benefit.
Perfect. So next we have a question from Mr. Pushpinder Nanda. So he asks, how do we ensure that the codes are strictly adhered to? I think he comes from a background where the Bar Council rules and the Advocates Act has a very strict code of conduct for Indian lawyers. We understand from your discussion that the law firms coming in and the practitioners coming in will also be governed by the same. But do you also see there being a necessity to have additional codes of conduct and rules being put in place for these foreign firms coming in?
Absolutely. I mean, the Indian lawyers would have a different set of rules, and their practice rule obviously would be different from what the foreign lawyers would be allowed to do. And not only in terms of the rules of practice, but also in terms of their etiquettes and what guidance they would have to follow. Very likely the Indian foreign lawyers would be restricted or subjected to as much as an Indian lawyers would be in terms of their compliances, or in terms of their, in fact, would be a stricter compliances. So there is nothing that Indian lawyers should be scared of. And I think it all depends on the Bar Council when they frame rules, how they should do it. And I think in most countries, that's how they do it. The foreign law firms' rules are much more stricter than the internal rules of the lawyers of that country.
Nice. Thank you, sir. So we have another question from Mr. Vijay Sharma. He asks, if foreign lawyers are allowed, how can we stop them from litigation or keep them just to solicitor practice? I think this comes from a background where jurisdictions like Hong Kong and Singapore have restricted foreign lawyer practices separately and have provided domestic lawyer jurisdictions. So do you think, one, protecting the bread and butter of some of our smaller lawyers, and if we can distinguish the practice between solicitors and advocates?
No, as I said before, the foreign lawyers firstly are not coming or not looking at India to do litigation practices in the Mufassil courts or even in the High Court or Supreme Court generally. Now, what his question is, how do you, if you can reflash the question?
Yes, sir. So I'd read his question again. If foreign lawyers are allowed, how can we stop them?
Yeah, so the rules, as I said, the rules will stop them from doing any litigation practice. So for any litigation practice, they have to go to a local litigation lawyers. And that's where my point is. My point is that a foreign lawyer who is established to practice foreign law in India would only have to go to a local lawyer, a litigation lawyer, to get litigation advice as well as Indian legal opinions. So my point is that it is beneficial for lawyers. In
Perfect.
fact, I'll give you another example. In fact, the foreign law firm would avoid going to a firm like us because they would think that if they come to us, they might lose the client, as I had given you an example. So they would rather go to a small individual lawyer and get an Indian law advice. So it's the Indian individual lawyers and small lawyers get to benefit.
Yes, perfect. So then we have our next question. As India is becoming a very lucrative commercial jurisdiction, do you think Indian lawyers are becoming very popular across the world? Therefore, is it important for us to restrict areas of practice for different kinds of firms?
As I said, I mean, Indian lawyers are one of the most excellent lawyers around the world. Indian universities at this moment produces one of the best lawyers in the world. I mean, as comparable to Oxford and Cambridge's. Many law firms actually goes out to the Indian universities and recruits directly. I have met several Indian graduates who are now working in different international and magic circle firms, which are the top of the line firms around the world. And many of them who have passed earlier have now become partners of these firms. You would see several Indian lawyers who have graduated from Indian universities are proud to be partners of big and very good international law firms.
Perfect. So then I think we're running out of time, but given that I'm the moderator, I have the advantage of putting the last question to you. So given that we are looking at the possibility of this reciprocity, how do you think Indian lawyers should first approach going overseas? We were looking at foreign law firms coming into India. How should Indian lawyers look at going overseas? What should be the qualities that they look at, they bring on their own, and what should be their approach?
Again, you're again forgetting. Indian lawyers, when they go abroad, there are two types of lawyers. One who are recruited directly by the international law firms, and
Yes.
the one who are going on behalf of a law firm or setting up a law firm internationally. Now, those who are going as lawyers in different international law firms, they are obviously recruited by these law firms, and they are excellent. And they go, as I said, to the partner level within the time frame that are with any other foreign lawyers. So in terms of foreign Indian lawyers working in foreign firm, there is no problem. With regard to the approach of Indian law firms establishing a foreign offices, obviously the concern is that they are restricted to practice Indian law. So how they approach in that country, let's say, for example, in New York. Now, if an Indian law firm opens an office in New York, they would apply, or their main client base would be US big companies who are come to India. They go to them in New York and come and get advice from that law firm that how they can come to in India and do their work. So a client goes to an Indian law firm in New York and takes the advice instead of coming all the way to India and take the advice. That's the advantage a client gets by using the same time frame to go and get the advice.
Nice. Perfect. Sir, thanks a lot. We understand your busy schedule in advising people across the world, not just private parties, but also governments and policymakers. And given the lockdown situation, the restrictions in London, and the differences in time, you've obliged us. And also, we need to thank you more particularly for another reason. We hear a lot of lectures from lawyers. They go off as if they are addressing the court. But it's one of the finest lectures that we've seen flow through the history of foreign lawyer systems in India, the court cases in the Madras High Court, the Mumbai High Court, and the collective lawyers and A.K. Balaji, and then leading to the Supreme Court. Thanks a lot, not just from me and from the organizers, but a lot of the audiences have been thanking through the chat stream continuously. Thank you again, sir.
Thank you very much. And
thank you, sir.
Thank you. Namaste.
Namaste. And before we wrap up, I have a few last-minute housekeeping stuff. So I would like and request all of our audience to start following us on Twitter and Instagram, like the Facebook page, and subscribe to the YouTube platform, and kindly feel free to share them with all your friends and followers. And a kind reminder to all our viewers to tune in tomorrow evening at 6 p.m. to hear Senior Advocate Sri C.S. Vaidyanathan to speak on dispute resolution as a service and the new normal. It would be great to have you more often, and thank you to you once again, sir, and thank you, the audience.
Thank you.